I have the pleasure today of introducing to you Mr. Kevin Lindgren. He was and is an academic, and he's one of the few speakers we have, despite his 6 degrees that he holds. I don't believe that one of them is from this university. However, he is the foundational holder of the Rule of Law Adjunct Professorship at this university for this year and through 2014. Mr. Lindgren has also practiced as both a solicitor and a barrister, most recently as Queen's Counsel, but you'll probably know him from his judgeship on the federal court between 1994 and 2010. Mr. Lindgren will be discussing his paper today, The Rule of Law, Its State of Health in Australia, which you can find on our Blackboard page. Please give a warm welcome to Mr. Kevin Lindgren.
Thank you for that very nice introduction. The topic, as stated, is the rule of law, its state of health in Australia. I have written a very, very long paper, and I will only be addressing parts of that in this lecture. I think the paper is really better read than heard, so I would encourage you, if I may, to read it. It will be available electronically. The rule of law is generally agreed to be a worthy ideal that must be treasured and preserved, at least until it becomes inconvenient. Yet there is no universal agreement as to what the rule of law is. The expression certainly signifies not a particular legal rule, but more generally rule by law, as distinct from rule by power, free of legal constraint, whether that power is exercised by a democratically elected government or by a tyrant or otherwise. The ideal signifies that the institutions of the state, and in particular the individuals and bodies invested with power by the state, should be subject to the law rather than above it. There are narrow and broad meanings of the rule of law. According to the narrow meaning, the rule of law is not concerned with whether a law is a good or bad law, but only with the question whether the law is applied equally to all. According to the broader meaning, the ideal embraces human rights standards. On any reckoning, both the rule of law and human rights standards should be respected, observed, and protected. So the question whether we go for the narrow meaning or the broader meaning tends to be a semantic one. Even if we treat them as quite distinct, a violation of the rule of law will often involve an infringement of human rights standards, and sometimes vice versa. In this paper, by and large, I have opted for the narrow meaning, but at times I certainly stray into human rights considerations. The expression the rule of law seems to have been used first, at least notably, by Professor Dicey. Professor Albert Venn Dicey published his book, Introduction to the Study of the Law of the Constitution, in 1885. He was the Vinerian Professor of English Law at the University of Oxford. He wrote about the English Constitution, and therefore about a unitary system of government rather than a federal one, such as those of Australia, Canada, and the United States. In a federal system, the sovereignty of Parliament is qualified by the bifurcation of power between the federal Parliament and the state or provincial parliaments. But within their respective fields, under the Federal Compact, the rule of law is relevant to both, that is, to the federal parliament and to the state or provincial ones. Professor Dicey thought that the rule of law had three meanings, and I'll briefly mention what they are. First, he said this, and before I quote, let me say that I first read Dicey in 1957, and having reread parts of Dicey now, it strikes me just how dated, sexist, and jingoistic he is. Very pro-British. You cannot help but feel as you read Dicey that he thought that the English alone had the rule of law and that other countries paled by the comparison. But having said all of that, his work is worth study. He said, "No man is punishable or can lawfully be made to suffer in body or goods except for a distinct breach of the law established in the ordinary legal manner before the ordinary courts of the land. In this sense, the rule of law is contrasted with every system of government based on the exercise by persons in authority of wide, arbitrary or discretionary powers." This first meaning of the rule of law, that everyone is subject to it, had been expressed very succinctly a long time before Dicey by Thomas Fuller in 1733. He said, in a phrase which I think is admirable for capturing this first meaning, "Be you ever so high, the law is above you." Professor Dicey contrasted the privileged position enjoyed by the French monarch and aristocrats, and in particular the oppressive treatment of French thinkers and writers of the 17th century, such as Voltaire and Diderot, with the rule of law which he saw as native to England. The second meaning that Professor Dicey propounded was this: it's not only that with us, the English, no man is above the law, but, what is a different thing, that here, meaning in England, every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Now, the emphasis in this second meaning of Professor Dicey is the word ordinary, the ordinary law and the ordinary tribunals. What he was saying is that we do not have a special body of laws governing those invested with state power, such as the police force, for example. He saw the fact that officers of the state are subject to the ordinary law and can be brought to account in the ordinary courts as essential to the rule of law. So, for example, if a police constable arrests you in excess of the legislative power given to the police constable, you can sue the police constable for the tort of assault in the ordinary courts, just as you could if somebody other than a police constable, a private citizen, assaulted you. So this idea of the ordinary law applying to state officials who can be sued in the ordinary courts was his second meaning. His third meaning of the rule of law was this: the general principles of the Constitution, and remember he's speaking about the English Constitution, not a written constitution, certainly not a federal one. The general principles of the Constitution as, for example, the right of personal liberty or the right of public meeting, are with us, the English, the result of judicial decisions determining the rights of private persons in particular cases brought before the courts. Whereas under many foreign constitutions, the security, and he says in brackets, such as it is, given to the rights of individuals results or appears to result from the general principles of the Constitution. Now, what was he driving at here? That the protections of the citizen under the English system, and the same argument would apply, subject to what I will say shortly, to other common law systems. The protections are to be found in the decisions of the courts recorded in the voluminous law reports. Dicey thought it was a good thing that the protections of the citizen are not, with the English, expressed in some sort of constitutional Bill of Rights or even in a statutory Bill of Rights. He thought it was a good thing that the protections of the individual were to be found in the decisions of the courts, the ordinary courts, built up over time. Now, if Professor Dicey were writing today, he would be faced with a quite different background from that which confronted him in 1885. For a start, the United Kingdom itself has its Human Rights Act 1998. And there are countries like Australia that do have a written constitution. You must have a written constitution if you're a federal system. But a constitution which lacks a declaration of human rights. It seems that if Dicey were living today, he would see as inferior as a protection of human rights not only the United Kingdom Act, but also Victoria's Charter of Human Rights and Responsibilities Act 2006 and the Australian Capital Territories Human Rights Act 2004. And what would Professor Dicey have made of the international treaties which have been agreed to in protection of human rights? Enough then of Professor Albert Venn Dicey. Next, I would like quickly to run through some of the major historical documents concerned with the rule of law. In the paper I call them the canonical instruments, which are bulwarks of the rule of law, and there can be no better starting place than Magna Carta of 1215. King John was in a difficult situation. The barons had him beaten, and one of their major grievances was the exaction of taxes from them without their consent. This idea of taxation without representation, interestingly, underlay both Magna Carta and in 1628 the Petition of Right, which we'll come to shortly. So the barons in 1215 confronted King John with their demand that he sign Magna Carta. And it contained 63 clauses in all, and some of them were concerned with this notion, no taxation without representation. They got him to agree not to impose taxes without the consent of, not the general populace, of course, but without the consent of the barons or representatives of the barons. And then further down in the document we come to clauses which are more relevant to our topic today. Clauses 39 and 40 of the Great Charter were as follows. No free man shall be taken or imprisoned or dispossessed or outlawed or exiled or in any way destroyed, nor will we, meaning the king, the royal plural, go upon him, nor will we send upon him unless by lawful judgment of his peers or by the law of the land. That was clause 39. And clause 40, to none we will sell, or to none will we deny or delay right or justice. Those two clauses are admirable expressions of aspects of the rule of law. Unfortunately, King John had not the slightest intention of ever keeping his promise to the barons. Not only that, but Pope Leo III said that the Magna Carta had been extracted from King John under duress, and the Pope purported to annul Magna Carta. It probably had been extracted from him under duress. We normally think of duress in the context of contracts, and I suppose that many treaties could be regarded as being extracted by the victor from the vanquished under duress, be that as it may. The fact is that it was ignored by King John, and as I said, the Pope purported to annul it. Yet Magna Carta has continued to have a strong symbolic effect. It was part of English law that was received into New South Wales upon settlement in 1788. The High Court of Australia has referred to Magna Carta in 40 cases, the Federal Court of Australia in 38 cases. And remember, the Federal Court was established only in 1976, about once a year. And the Supreme Court of New South Wales in 32 cases. Now let me immediately acknowledge that in not one of those cases was the Great Charter relied on as the basis for the decision. And in nearly all of them it was referred to only in passing. So I'm not suggesting for a moment that the terms of the Magna Carta have influenced decisions in particular cases. My point is that the frequency of its citation makes the frequent reference by the courts to the rule of law, which it has come to symbolise, worth noting. And it still forms part of our law in Australia. The next major instrument is not really a legislative instrument, it's the writ of habeas corpus. Probably you're aware that the writ of habeas corpus is a writ, a court process, which requires someone who has another person in detention or in custody to bring that person before the court so that the lawfulness of the detention or custody can be tested. Habeas corpus literally means have the body, and it means have the body, it's an order, have the body before the court. Bring the body before the court. The person who has control of the body, the person brought before the court, is required before the court to justify the detention as being a lawful detention. So the writ of habeas corpus over the centuries has been addressed to governors of jails, for example. It might be addressed to the superintendent of a hospital for the mentally ill. It might be addressed to the superintendent of an immigration detention centre, for example. Habeas corpus proved to be very important in the series of cases concerned with detainees at Guantanamo Bay, about which I'll say something a little later. Just by way of digression, it's interesting, isn't it, that English writ has proved important in other common law systems, derived ultimately from the English system, like the United States of America and Australia. The next of these important instruments is the Petition of Right of 1628. In 1628, 5 knights were imprisoned. They were imprisoned because they would not make loans to King James I. To King Charles I. I was thinking, driving here this morning, it's interesting that we usually think of the lender as having the more powerful position in a loan situation. But in this case, Charles I, the borrower, had the power on his side. So he imprisoned the 5 knights for refusing to lend him money to support his military aims. One of the 4 gave up the fight. All 5 of them, first of all, sought the writ of habeas corpus to bring the 5 of them before the court, and then 1 gave up and made the loan to the king, but the other 4 fought on. The outcome of the proceeding was unsatisfactory. The court remanded the 4 knights who persisted back to prison, in effect on bail, without delivering a final judgment. In substance, then, the case itself was a refusal of bail case. But in fact, in practice, it did lead the 4 of them also to make loans to the king. So he got what he was after. However, Parliament treated all of this as very unsatisfactory, and they presented to the king a petition of right. It's called a petition, but later it was treated as a statute of the Parliament and the king. And Clause 8 of the petition of right stated this: "They," meaning the parliamentarians, the members of Parliament, "do humbly pray your most excellent Majesty that no man hereafter be compelled to make or yield any gift, loan," a reference to the 5 knights, "benevolence, tax, or such like charge without common consent by Act of Parliament, and that none be called to make answer or take such oath or to give attendance or be confined or otherwise molested or disquieted concerning the same or the refusal thereof." So without the consent of Parliament, people were not to be imprisoned for declining to make a loan to the king or to pay a tax. The third instrument is the Habeas Corpus Amendment Act of 1679. I won't be going through many more, maybe one other instrument, and then we'll come to Australia today. The monarchy was restored in the year 1660 after the English Civil War. Charles II was the restored king, and his chief minister, whose name was Edward Hyde, the first Earl of Clarendon, in the exercise of executive powers, made a practice of dispatching prisoners to outlying parts of the United Kingdom so that the writ of habeas corpus was not available to them. the writ of habeas corpus was only available in England and Wales. So what Clarendon would do would be to dispatch troublemakers to foreign places, still under the control of the British, garrisons and forts and so on, islands elsewhere than in England and Wales, so they couldn't have access to habeas corpus. They couldn't get to the courts. When he fell from power in 1667, Clarendon was impeached, and one of the charges against him was that he had sent persons to, and I quote, remote islands, garrisons and other places, thereby to prevent them from the benefit of law, unquote. Clarendon fled England and died in exile. It was not until 1679 that the House of Lords, by a majority of only 57 to 55, passed the Habeas Corpus Amendment Act 1679, which remedied this provision and said that no longer could you put people outside the reach of habeas corpus. In more recent times, the motive of the United States government in detaining terrorist suspects at Guantanamo Bay was the same as that of Clarendon, an attempt to put people outside the reach of habeas corpus and the ordinary courts. One motive of both government and opposition parties in the Australian Parliament in supporting offshore processing of applicants for refugee status is at least partly the same. Access to lawyers and to the courts can be an inconvenience, and this is a subject to which I will return later. Well, when you read this paper, if you do, you will see that I then go on to deal with the Bill of Rights of 1689 and the Act of Settlement 1701, which went some way towards ensuring the tenure of judges. And I do mention the American Bill of Rights, the French Declaration of Rights, and international instruments. But let us move on then from Professor Dicey, the major documents concerned with the rule of law, now to Australia in 2012. Potential threats to the rule of law with particular reference to Australia. In this part of the lecture I will address a number of potential threats to the rule of law in our country. First, I want to talk about the independence of the judiciary, and I probably will finish up talking about this more than any other of these topics. Under Section 72 in Chapter 3 of the Australian Constitution, the period of tenure of all federal judges is until the attainment of the age of 70 years. Too young, in my opinion, but there we are. I'm not against the idea, personally, of a retirement age, but a person as youthful as I am should not have been compelled to retire at the age of 70. During the tenure of federal judges by Section 72, the remuneration of the judge cannot be diminished while he or she holds office. The idea being that if it were possible to reduce the remuneration, that would be not just a way of penalising a judge who had displeased the government, but possibly getting rid of that judge if you reduce the remuneration sufficiently. So maintenance of the level of remuneration, not necessarily increasing it, but maintenance of it is required by the Constitution. And finally, and I suppose most importantly, until the judge attains the age of 70 years, I'm speaking here about federal courts, the the High Court of Australia, Federal Court of Australia, Federal Magistrates Court, Family Court of Australia. During that tenure, a judge cannot be removed except by the Governor-General in Council upon an address from both Houses of Parliament, quote, on the ground of proved misbehaviour or incapacity, unquote. There are generally similar provisions to those that I've just outlined in the states and territories, although the age varies. For example, in New South Wales, the age is 72 years, not 70. And in addition, in the states, it is possible to appoint acting judges beyond the age of 72 years, whereas acting judges are an impossibility under the federal constitution. The safeguard in section 72 of the Constitution is a bulwark for federal judges to, and I quote, do right to all manner of people according to law without fear or favour, affection or ill will, unquote, as the Judicial Oath expresses it. And I'm quoting from the Federal Court of Australia Act 1976. The state and territory versions of the Judicial Oath are virtually identical to the federal one. The one in New South Wales includes the words according to the laws and usages of New South Wales, I think. Slight difference. The inability of the politically powerful to remove a judge from office or to lower the judicial salary supports the maintenance of the rule of law by the courts. And at this point, I want to turn, I hope briefly, to recent events in Papua New Guinea. The attack on the rule of law up there, and in particular on the Supreme Court, gives cause for great concern. Events have been moving so rapidly that it's difficult to be sure that one is completely up to date. The background can be summarised as follows. By mid-2011, the Prime Minister, Sir Michael Somare, had spent some months in a hospital in Singapore. The majority of the members of the National Parliament, who have throughout supported Somare's political opponent, Peter O'Neill, decided to withdraw their support for Somare and to elect O'Neill as Prime Minister. In accordance with that decision of the Parliament, the Governor-General of Papua New Guinea, Sir Michael Ogyeo, then appointed O'Neill as Prime Minister. A challenge was mounted in the Supreme Court to the removal of Somare from office. After the hearing of that challenge in the Supreme Court, and while that court's decision was reserved, and against the prospect that it would be adverse, the Parliament enacted legislation and passed a number of resolutions on the 9th and 12th of December 2011. The resolutions included the election of O'Neill, again as Prime Minister. The decision of the court was given on the 12th of December. By a 3-2 majority, the court found that Somare's removal had been unlawful, and the court ordered his reinstatement as Prime Minister. Now, of course, one can understand the O'Neill faction, with a very large majority in the Parliament, being bitterly disappointed in that decision. But respect for the rule of law would have led to its acceptance and, I presume, to a vote of no confidence in the Parliament, in Somare, and an early election. That's the normal way in which that sort of problem is handled. But that was not to be. In recognition of the court's order, Governor-General Ogyeo refused to appoint O'Neill Whereupon, on the 14th of December, the Parliament suspended the Governor-General and declared that in view of the consequential vacancy in the office of Governor-General, the Speaker of the Parliament had automatically, under the Constitution, become acting Governor-General. Acting in that capacity, the Speaker appointed O'Neill as Prime Minister. There is no evidence that the Queen revoked Sir Michael Ogio's commission as her Viceroy. On the 19th of December 2011, Governor-General Ogio and the Parliament again recognised O'Neill as Prime Minister. There were subsequent related events. 2 police commissioners were appointed by the rival factions, and in January there was an attempted mutiny by about 30 soldiers who placed the head of the Papua New Guinea Defence Force under house arrest. In February 2012, the National Executive Council decided to appoint a tribunal under Section 179 of the Constitution to investigate the Chief Justice for misconduct and to suspend him under Section 182 of the Constitution. However, the Supreme Court stayed that decision on the 2nd of February. Of course, the bench did not include the Chief Justice. That manoeuvre occurred just before the Attorney General... I'll withdraw that. In March 2012, the Parliament passed an act providing for judges to be removed for bias. The act is the Judicial Conduct Act 2012. Now, the Constitution of the independent state of Papua New Guinea already provided a mechanism for the removal of judges for proved misbehaviour or incapacity in terms not altogether different from those of the Australian Constitution. So it seems to me that there has to be a question about the validity of the act that the Parliament passed when the Constitution provided for a mechanism for the removal of judges. This Judicial Conduct Act 2012 provides in Section 5, subsection 1, that a judge must disqualify himself in and must not influence a proceeding, and I quote, in which the judge's impartiality might reasonably be questioned, unquote, an objective standard. Where it appears to the Parliament, and remember the O'Neill faction has a vast majority in the Parliament, where it appears to the Parliament that a judge has contravened this provision, that is, not disqualifying himself or herself, the Parliament may by motion refer the judge to the head of state to appoint a tribunal to investigate the contravention and report to Parliament, or may refer the matter to another authority for appropriate course of action. Upon receipt of a referral, the head of state must appoint a tribunal of 3 judges or former judges which must make due inquiry, quote, without regard to legal formalities or the rules of evidence, and inform itself in such manner as it thinks proper, subject to compliance with the rules of natural justice. If the tribunal reports a contravention, that is a wrongful failure to disqualify himself or herself by the judge, Parliament is to take, quote, whatever action is necessary, unquote. And so on. The nub of it all really is a determination by the political controller or controllers, that is, the majority faction within the Parliament, to bring the troublesome majority of 3 in the Supreme Court to task. Once Parliament has referred a judge to the head of state before any finding, that judge must not exercise judicial office pending the provision of the report by the tribunal to Parliament. And if it is the Chief Justice who is referred, the Deputy Chief Justice is to act as Chief Justice. Perhaps the most egregious aspect of this Act is its retrospectivity. The Act states that it came into operation on the 1st of November 2011. That's well prior to the decision of the Supreme Court on the 12th of December, reinstating summary. The passing of this Act drew protests by students and criticism by veteran politicians that it damaged the independence of the judiciary and therefore the rule of law in Papua New Guinea. One gets the feeling that the majority faction still felt that it somehow wasn't achieving all that it wanted. And so on the 4th of April, the Parliament voted directly to suspend the Chief Justice, Sir Salomo Injia, and Justice Kerwom, two of the three judges who had formed the majority of three on the 12th of December. There were protests. On Tuesday the 10th of April, in response to those protests, Peter O'Neill publicly announced that if those two judges would stand down voluntarily, Parliament would repeal the Judicial Conduct Act. There are many other aspects of what's been happening in Papua New Guinea that could be mentioned and explored in detail. And some of these things may strike you as unimportant, but to my mind, they are telling. Unimportant in themselves, but an indication of people who are absolutely determined to bring the court under control. For example, there have been in circulation 2 copies of the Judicial Conduct Act 2012, both of them certified by the Speaker of the National Parliament. One of the 30th of March and the other of the 4th of April, which contains additional provisions. How could you possibly have that? The Speaker certified one of the copies of the Act as the Judicial Control Act 2012, not the Judicial Conduct Act. Realising the mistake, the Parliament in the Judicial Conduct Amendment Act 2012 amended the Speaker's certification. The latter Act, that is the Amendment Act, introduced a provision to the effect that where a judge has been the subject of a resolution of the Parliament under Section 5, I note that Section 5 provides for 2 kinds of resolution, not one. If the judge exercises judicial power, or another judge exercises judicial power with that judge, the judge, or other judge, commits an offence and is liable to imprisonment for a term not exceeding 7 years and a loss of all retirement benefits. And becoming increasingly bold, the Parliament on the 18th of April 2012 passed an act called the Supreme Court Amendment Act 2012, rendering, quote, null and void, unquote, the Supreme Court's declaration and order of the 12th of December 2011. So at long last, it's all out in the open what they were seeking to do, which was clear enough from the beginning, I suppose, but now it's done directly in the exercise of parliamentary sovereignty. The Parliament declares null and void a decision which displeased it back on the 12th of December. Well, these events, and no doubt there have been further developments since I wrote that. Things have been happening on an almost daily basis, and it is very, very concerning. Now, I'll say a word or two about the fortification of the rule of law in the Australian states on the basis of Chapter 3 of the Constitution. And then I'll come to what I find quite interesting, subtle potential threats to the rule of law in Australia. And then I think we'll be finished. In recent years, the High Court has fortified the independence of the judiciary in Australia. As previously noted, the federal courts, that is, courts created by the Commonwealth Parliament, are independent by reason of direct provisions to that end in Chapter 3 of the Australian Constitution. Of present interest, however, is the way in which the High Court has found in the Constitution implied requirements which the state Supreme Courts must satisfy. And by that process of implication, the High Court has extended to the state Supreme Courts the independence requirements, not to the letter, not, for example, the age of 70 years as against 72, but independence from the executive to the state Supreme Courts. A very brief summary of the way in which the High Court has done this is this. It has done so by two lines of reasoning. The first line of reasoning is that the Australian Constitution presupposes the existence of state Supreme Courts. And for the state Supreme Courts to satisfy the concept of a, quote, court, unquote, they must possess a minimum of certain features, including independence from the executive. So that's the first line of reasoning in some of these cases, which I'll refer to briefly. The second line of reasoning is a little more direct. It is this. The Australian Constitution vests in state courts federal judicial power, as well, of course, as vesting it in the federal courts themselves. Since the Constitution provides for the vesting of federal judicial power in the state Supreme Courts, it would be inconsistent with the Constitution for that judicial power to be exercised by state Supreme Courts that did not satisfy the relevant criteria that the Constitution requires courts created by the Parliament itself to satisfy. I've said that rather quickly, but they're the two strands which you can find in the recent constitutional cases before the High Court. The first of those cases was Cable versus Director of Public Prosecutions, New South Wales. That was the case providing for detention of a prisoner after expiry of the prisoner's term of imprisonment for the offence. And that was because of fears held that Mr. Cable would perpetrate further acts of violence if he were released. The problem was that the legislation co-opted into the system, and I won't have time to go into detail, the Supreme Court as one actor involved in the process by which Cable or others could be kept. And the High Court said, no, you can't use the Supreme Court as it were as part of the executive. It has to be independent. And there have been other cases, I think I won't have time to mention them all, but you can read them in the paper. I'll now come, because I do want to touch on this before we conclude, what I call more subtle influences on the judiciary. Subtle influences on the judiciary in Australia. Might a judge be inclined to decide cases in favour of the government in the hope that this will lead to his or her being appointed by the government to a higher court in the future. I can tell you it never ever occurred to me when I was a judge that I might, just by deciding this case in favour of the government, be appointed to the High Court of Australia. Wow, just think of that. Never occurred to me. And what I would say about that theoretical possibility is that I suggest it is entirely theoretical. If it were of concern, we could have a law that says that no judge, no serving judge, can be appointed to any higher court, full stop. Now, you could do that, but if you did, think of the talent of which we would all be deprived on the High Court of Australia, for example. I think it's right, isn't it? They're all judges there at the moment, were serving judges elsewhere, every one of them. My former colleague, Chief Justice French, could not be Chief Justice on the High Court. Former Chief Justice Gleeson. Anyway, we need not go on. Well, my own view is that that's a theoretical but not a real problem for the rule of law. A second potential threat worth considering lies in the requirement of managerial accountability that is imposed on courts by government departments. Of course, the word accountability, like motherhood, suggests an idea of which no criticism can be tolerated. Yet if the performance of courts is to be gauged by statistical criteria, such as the number of judgments produced, the number of days spent by judges in the courtroom, the number of cases finalised, the number of pages of transcript of proceedings recorded, and so on, courts, and in particular their chief justices, could be tempted to tailor the way that courts function to the detriment of the rule of law. I don't suggest for a moment that that has happened, but it does concern me sometimes. I'll just mention one story, rumour that I heard, and I have forgotten if I was ever told which court did what I'm about to say. And if I was told and remembered, I wouldn't tell you. But the rumour was this, that in providing statistics on the number of proceedings commenced and finalised, one State Chief Justice somewhere recorded as a proceeding every admission of a solicitor or barrister to the court. Now, you're quite correct to do so, because if you apply for admission as a solicitor or barrister, as many of you will do, a proceeding is commenced by you in that court. In fact, it has a very early termination date too. Wonderful for the statistics, terrific. But assuming that all other Supreme Courts are not doing that, and the Federal Court can't do it because people are not admitted by the Federal Court, you get warping of the statistics. Now, that illustration is totally innocuous and has got nothing to do with the rule of law, but it's just an indication of the way in which courts can be tempted to tailor statistics in order to get funding and so on, and to show that they are being kept busy. Another potential threat comes from the media. Happily, in my experience, ill-informed criticism of judges is ignored by them, but that's something to be watched. There is the issue of acting judges. In the case of Forge, the High Court indicated that it would be wrong if the judge complement of a court was dominated by acting judges. In other words, it's lawful for the state Supreme Courts to use acting judges, but not too many. There is the necessity to ensure that appointment is on merit, and I personally support the former Attorney General McClelland's introduction of the panel system for federal courts, although I think that system has not worked out too well in practice because of delay. That's another matter. And the last thing I want to mention is competition between courts, something which is not, generally speaking, referred to. Where litigants have a choice of court in which to commence their proceeding, say between one state Supreme Court and another state Supreme Court, or between the federal court and a state Supreme Court, if the kind of work is interesting work and stimulating, a court will hope that it will be chosen for various reasons. It's important that a court have an interesting diet of work for the present judges and for appointees in the future. But it would be wrong for a court to tailor the way that it operates in order to attract the repeat interesting work. And with this I will conclude. Not courts, but this was a story I heard about arbitration. There are certain parties which are repeat parties before arbitration, in particular insurance companies. And the story I heard, which comes from America, was that one particular arbitrator gave a decision in favour of the insurer in 19 successive arbitrations. In the 20th one, he gave a decision against the insurer, and he never got another arbitration from that insurer. Now you could say, well, what does that prove? Well, to me at least it suggests that courts, I suggest arbitrators as well of course, should do nothing to attract interesting work. With that we'll conclude.